Mr. Mateer, let's cover a couple of things, hopefully very quickly. Let's talk about this forensic report that he introduced as Attorney General 361. And he talked to you about, I'm sorry, do you want the, Mr. Busby, are these your notes? Mr. Busby.
Mr. Busby?
Mr. Busby,
he's asking if those are your notes.
You want these back? Yeah. Thank you.
And Mr. Hardin, please speak up. You're speaking softly.
Thank you very much, Your Honor. I've been mindful of my failings in this regard. Let me ask you this. On Exhibit 361, he talked to you about Lacey May's email that talked about that $50,000, correct?
Yes.
And he made a very big deal, did he not, about the fact that that this was on October the 1st, so that the jury remembers the day that the group of you went to the FBI was what date?
Was the day before, September 30th.
All right. And on the date, the date of October the 10th, is that when you sent the email or text that Mr. Busby asked you about to the Attorney General asking to meet with him?
It's actually October 1st.
That's October 1st.
Yes.
The gathering of all of y'all that we've talked about in that conference room where you found out about the subpoenas was on what date?
That was the 29th.
All right. And on the 29th, I think you described the mood everybody was in and the concerns everybody was. On the 29th, is that when you initially thought and talked about setting aside $50,000 for the group of you to represent Mr. Sutton, the Attorney General's office, as opposed to you as individuals?
Correct.
What was your thinking as to why y'all needed a lawyer for the university, for the Attorney General's office?
Because we were trying to navigate through this with potentially going to law enforcement. And so we wanted someone who had that type of experience at that level.
All right. You knew Mr. Sutton had criminal defense lawyer as well as previous criminal prosecution experience, did you not?
I did.
All right. And each of you, or did all of you know him from past dealings?
Yeah, I didn't know Mr. Sutton very well.
But most of you did.
It did. I knew one of his, I guess, former partners really well, which was John Ratcliffe.
All right. That at sometime that day, did you as a group decide that was not a good idea?
We did eventually decide that, yes.
Was that after you had authorized the exercise of paperwork to make it possible?
Well, what we did again was my email was making sure and seeking confirmation that there were funds in the event we decided to do that. We did not do that. Had we done it, we've gone at length through this executive approval.
Real quickly, if in fact you had decided to follow through on that request that had been put aside, what would you have had to do to get it authorized and done?
We would have had to go through the executive approval memo process, just like we've seen, and everyone would have had to sign off.
And that process would have been necessary before any of the funds would have been expended or even eligible to expend. Is that right?
Before funds are expended or a contract is executed.
All right. So before a contract could have been worked out with Mr. Sutton, you would have had to go through all of that. If you were going to do it on behalf of the agency, you would have to go through all that cumbersome process, correct?
That's correct.
And how long would that have taken ordinarily?
I mean, it can be done within a day or so.
All right. But in the meantime, had each of you decided that you needed to go to law enforcement, and after thinking about different agencies, different possibilities, you settled on the FBI, correct?
That is correct.
DPS had agents that he had been complaining about, correct? That Mr. Paul had.
Yes.
And so in the other agencies that had law enforcement people had been involved, such as the district attorney's office, correct?
Correct.
Objections. Your Honor, I'm sorry.
That's true. I withdraw it. All right, let me move on.
I mean, multiple leading questions. I just wish he would just ask a
All right,
question.
multiple on a single. My
rephrase.
problem is, if he just says objection and gives his basis and stops, it doesn't get charged in my time. But we've now had a bunch of time where these kind of speeches have eaten us up. I'll come to you at the end of my statements. I'll withdraw the statement and proceed.
Thank you. And in fairness, both of you have kind of elaborated a little bit on objections, so let's continue. But I will watch it very carefully on both sides.
Yes, thank you very much. Now, if I could, would you please tell me when it was in this process y'all decided to go to the FBI and hire Mr. Sutton personally on y'all's behalf rather than the agency?
We initially contacted Mr. Sutton on the 29th. We reached the decision that the agency doesn't need to contract with Mr. Sutton later on the 1st.
So was there ever any attempt to get $50,000 from the agency, to use $50,000 from the agency, or follow up at all on authorization?
We never started the memo process at all, which was essential to do that.
Are you aware when we're talking about computer time and everything of universal time?
Say that again.
Are you aware of universal time?
Now that you say it, I am, the concept.
I want to just get a note if I can. Do you recall Mr. Busby spending a great deal of time with you on both the Lacey Mays email or the attachment to the forensic report, and suggesting that it was at 1:39 on October the 1st?
I mean, the document says that. I see.
Does it come any surprise to you that if you go on the internet and check out what universal time is, which is what this was, it would have been at 8:39 the day before, not on October 1st?
That makes sense.
If what I have just said to you is true and accurate, would that have meant that y'all were still talking about authorizing the money on the 30th, as opposed to October the 1st, as Mr. Busby was saying?
Yes, sir.
And regardless, when you went to the FBI on the 30th, did Mr. Sutton accompany you?
I believe so.
All right. And by that time, had y'all orally retained him to represent you individually instead of the company, the agency?
Yes, sir.
Do you have any evidence or knowledge at all that Mr. Sutton even knew that y'all had originally talked about retaining him for the agency?
I had no discussions with him.
Okay. So would it be consistent with your level of knowledge that Mr. Sutton would not even have known that y'all had talked originally about hiring him on behalf of the agency?
Based on my knowledge, that's correct.
All right. And then finally, he asked you about this one issue. He asked you about some grand jury subpoenas. At the time that the grand jury subpoenas were shared with Mr. Sutton, was he your lawyer?
Yes.
And was he representing y'all individually?
Yes.
What is your position as to whether anybody who thinks they may have a problem or need a lawyer can share the evidence or the information they're concerned about with their lawyer?
I think you can share information with your lawyer.
And did any of you give any alleged grand jury subpoenas to Mr. Sutton before you had retained him?
I did not.
Okay. Now, I want you ask, when you go to the FBI, just a couple more areas. I believe you said you have no criminal law experience. Is that correct?
When I was at Carrington Coleman, Mr. Coleman made us all take a couple criminal cases. So when I was a first or second year associate, I actually did do a couple criminal cases.
But other than that, what is your experience? If one is reporting a crime, what they believe may be a crime, to law enforcement, do they wait till they're able to establish beyond a reasonable doubt before they report the possibility of a crime?
I don't think that's what you do.
When you went to the FBI, did you go with them to express your concerns and hope that they would look into it?
We just wanted to tell them what was going on.
Did you make any determination as any kind of expert on criminal law as to whether things were or were not a crime?
Not at that time, no, sir.
All right. Finally, on this area, regardless of whether it's a crime, what is your position as whether you were concerned about two particular areas specifically? Whether or not what Mr. Paxton had been doing and authorized and loosened on the world was an abuse of office. Did you have any thought about whether it was an actual specific crime for this or not? What was your thought process?
I thought I had a belief that it was.
Would you still have that belief even if it turned out this or that individual thing was not a crime?
That was based all upon what I knew at that time.
What do you mean?
Well, we knew what we knew. I mean, knowledge on that date. Therefore, based upon the actions that I discussed with you earlier today.
What was your view as to whether or not, if the Attorney General's office, when its own internal people believed the incident at issue was not a crime, if they did not, and it should not be investigated and should not be opened to the file, if your own internal people felt that way, for then somebody on behalf of the office be hired to go out and use grand jury subpoenas to punish the enemies of a friend or a donor, did you have a position whether that it was a crime or not? Did you have a position of whether that was an abuse of the office of the Attorney General?
Objection, Your Honor. That was 3 questions, and it was all 3 of them were leading.
I believe he can answer each.
Sustained.
I'm sorry. Excuse me. Sustained.
Sustained, yeah.
Thank you, Judge. Did you have an opinion as to what your really hardcore belief was as to that conduct that you believed he had engaged in, as to how that complied with the oath of the Attorney General of the state of Texas?
Yeah, I believe that it violated the oath
Why?
because he was taking actions not on behalf of the state of Texas, but on behalf of one individual.
Against?
He was aligning against other parties, in this, against law enforcement.
Did you have an opinion one way or the other whether he was, by what he was doing, it was interfering with federal and state investigations, criminal investigations?
That appeared to be the case.
Okay. Finally, if you signed on, you authorized the intervention in June of 2020 into the Mitty Foundation case against Mr. Paul's companies, correct?
I did, yes.
If you knew then what you knew now, would you ever have authorized intervention?
I would not have.
That's all I have.
Recross, Mr. Busby?
Yes, Your Honor. You told us all that it was against the charity and for Nate Paul. That's what you said? The intervention?
The intervention was to intervene into that lawsuit, yes, sir.
No. You told us, in response to the leading questions of Mr. Hardin, that the intervention was against the charity and for Nate Paul. Isn't that what you said?
I think what I meant to say, if I said that, and I'm not so sure I did, it was to intervene into the lawsuit between the two parties, and then there was also, as you know, an investigation into the charity.
So it wasn't against the charity, was it?
It was to intervene into the lawsuit.
Yeah. It wasn't against anybody. It was an intervention, wasn't it?
The intervention was an intervention.
It was an intervention that you authorized,
On
right?
June 8th, that's correct.
And you also authorized an investigation, didn't you?
I believe on the same day or about the same day, yes.
And the impeachment articles, pull it up, please, Article 1. Let's look at it. Paxton caused employees of his office to intervene in a lawsuit. You see that language?
I do, sir.
He didn't cause anything. That's something that each of the people on the executive action memorandum approved. Isn't that right?
We'd ask those people who on that memo.
Yeah. I'm asking you, you're on the memo. You approved it.
I did approve it.
Okay. So this article is hogwash, isn't it?
I think we would need more information.
And you were telling us, that those timestamps in these documents that were given to our side, at least by Mr. Hardin's office, you're saying those were universal time?
Again, I was reading the document like we all were.
Wait a minute. I'm just asking about what Mr. Hardin, the back and forth you had with Mr. Hardin. He asked you about universal time, remember?
Showed a document that had the reference to universal time.
Okay, and you were telling us that universal time, that these documents would not have been 1:30 in the morning, but would have been 8:30 prior? Or you don't know?
What I know is it is very, extremely unlikely that I was looking at any email at 1:30. Now, 4 a.m., 9:30 p.m., yes. 1:30, I don't think so.
Well, let's real quick. I believe it was 368, AG 368, if my memory serves. And let's go to the authorization email, so the members of the jury are clear about what you were up to. Can you tell us whether you had already retained Johnny Sutton at the time you sent this email to Lacey Mays?
I would need to know the conversion to the universal time.
Well, I'm not asking about that. I'm asking in your memory. We know for a fact you told us before you went to the FBI on September 30th that you met or talked to Johnny Sutton, that you retained him, right?
That is correct, sir.
Okay. Can we agree that you had retained Johnny Sutton individually before you went to the FBI?
Yes.
And can we agree that after that, according to you, and your story is now, y'all were also thinking about hiring Johnny Sutton for the office itself, right?
We were, yes.
Wouldn't that be a conflict? How the devil is Johnny Sutton going to represent you in your individual capacity and also represent the Attorney General's office when the actual client in the Attorney General's office would be the Attorney General himself?
That's why we wanted to meet with the Attorney General, among other matters, on October 1st.
You're telling this jury, all public servants, all elected, that you thought it was okay for you to hire some outside lawyer in your individual capacity and to also even discuss the office might hire him as well? You think that's okay?
I think it can be okay, yes, sir.
Would you at least agree it wouldn't be okay to have Johnny Sutton be paid for by the Texas taxpayers for your individual representation?
Yes.
That would be a crime, wouldn't it?
I don't know if it's a crime, but it didn't happen.
It didn't happen because you resigned.
No, we made the decision not to hire him by the agency.
Told us how, all this stuff was done for Nate Paul. Remember talking about all that?
We discussed Nate Paul, yes.
And for a fact that Nate Paul was a pain in the butt, wasn't he?
I think that's fair to say.
He was a pain. He was a constituent that wanted action, right?
He certainly emailed a lot of people in the office.
I said in the opening statement, when he said jump, he wanted you to jump and just hope you jumped high enough, right?
I think we've examined his contact with me.
You've heard the term, the squeaky wheel gets the grease.
I do know that one.
Sometimes there's in constituent services, there's somebody who's a real pain who is over and over and over demanding action. And sometimes there ain't a whole lot you can do for them. Isn't that right?
That does happen, yes, sir.
Yeah. That's how Nate Paul was. Isn't that right?
He was more than that.
Yeah. He sent letter after letter after letter after letter making threats and accusations to the AG's office, didn't he?
He did, through his lawyer and himself.
Yeah, email after email. He was incredibly unhappy with the action of the AG's office, wasn't he?
I believe at times he was, yes.
He was madder than a hornet's nest at times at the AG's office for what he called incompetence and failing to act. Isn't that right?
The best source of that would be ask Mr. Paul.
Yeah. And you know this is true because he sent you all of his correspondence that he had been sending to Josh Godby, accusing Josh Godby of having a conflict. Remember that?
I don't know if he sent me all his correspondence, but he did send me correspondence.
He claimed the AG's office had a conflict because the spouse of the receiver in the case worked at the AG's office, right?
If you have it, I could look at it.
Yeah.
I don't.
And he thought that was the reason Josh Godby wasn't doing anything because Godby had a conflict. Isn't that right?
If you could show me the documents, I could look at it.
Well, he sent them all to you. Don't you remember? And we looked at them in your direct.
We didn't look at all of them, sir.
Okay. Let's look at AG Exhibit 219, Eric. I'm just going to hit the high points. This is an email Nate Paul sent to you in July of 2020 where he was very upset, very frustrated with the AG's office. Do you recall receiving this email?
1 second, sir. It appears to be familiar, yes, sir.
He says, these emails started a month ago and continue to be ignored. See that part? First paragraph, last sentence.
I'm looking. That's what it says, sir.
Go to the next page, Eric. He's sending you a ton of different emails that he sent to Josh Godby. Here it is where he tells Josh. Josh was your direct subordinate or one level below you?
No, Josh would have reported to the deputy for civil litigation.
Which was?
Darren McCarty.
Okay, so this would have been you, McCarty, Josh Godby.
Yes.
Okay.
With an associate deputy to McCarty there as well.
Here he tells Josh Godby point blank, you've exhibited highly unprofessional behavior. You see that?
Yes, I said you've read that.
He says, your relationship with Greg Milligan, that was the receiver in the Mitty Foundation case, wasn't it?
I don't know.
Well, we all know. He says, your relationship with Greg Milligan and opposing counsels has clearly affected your ability to be neutral. You see that language?
I see the language.
He's accusing, yes, sir.
Excuse me, this has not been admitted into evidence yet, I believe.
219 is not in evidence? Your Honor, we offer 219, just to make it fast.
Any objection? Continue.
Thank you, Your Honor.
It's admitted to evidence.
Thank you, Your Honor. Looking at he accused the AG's office of having a conflict of interest, didn't he?
Did you read that?
Yes, sir, I did. Clearly affected your ability to be neutral. That's called conflict of interest, is it not?
It says not to be neutral. That could lead to a conflict of interest.
I'm just trying to figure out how Nate Paul had the keys, as we've been told, to the AG's office when he keeps haranguing the AG's office for failing to do its job. Any answer to that?
Any answer to that? He certainly.
Let me go to this.
Would you like me to answer or no? No?
You can answer. If you have an answer as to how we are being sold this bill of goods that the AG's office had been handed over to Nate Paul, yet we see the real-time correspondence where he's haranguing the office over and over and eventually haranguing you. You see that, right?
Now, can he answer the question, Your Honor? Please.
Thank you, Your Honor. Let's take a look so we can end this up Exhibit,
Your Honor, I asked those last questions then. My objection is to be stricken from the record. He asked this question. He gave a speech. If one looks at exactly what he did with his answer there, the witness asked if he could answer. Do you want me to answer? And then he gives his speech about, well, if you can do so and so. And then he withdraws the question. So he's made a speech and testified and not allowed the witness to answer. I respectfully ask that last question be struck and he be allowed to answer the question before that.
I'll withdraw it, Your Honor. It's fine.
I'll bet.
Finally, Eric, let's look at Exhibit 127, Exhibit 40. What is a litigation hold? What does that mean in the parlance of lawyering?
Well, what it means is when you either send or receive one, it's to not delete anything.
Does that include text?
It includes any correspondence that's relevant to the subject of the request.
Now, would you agree, I mean, you've been a lawyer for 26, 27 years?
Actually longer.
Okay.
I was licensed in 1990.
Okay.
So I think that means I'm 33 years.
33 years.
Yes, sir.
Okay. You know, as a member of our profession, that when you send a litigation hold letter, that means preserve everything related. I may be suing you, right?
That is true.
Did you know that Nate Paul's lawyer sent that to the AG's office?
Yeah, on October 11th, 2020.
Yeah. So 9 days after you left, Nate Paul was threatening to sue the office for inaction, for having a conflict, etc. Isn't that true?
I mean, this is a letter that's sent to Mr. Webster and Mr. Paxton. I'm not at the office any longer. I can read it if you want, if you have it.
That's fine, sir. Your Honor, with that, I pass witness.
Ready for the next witness, Your Honor?
Witness is excused.
May this witness be excused and stay available if there has to be some recall, but certainly not around.
You're excused, but subject to recall. You may step down.
Thank you, Your Honor. Your Honor, we call Mr. Ryan Bangert.
To both parties and the jurors, I plan to go to about 6:30 this evening, depending where we hit a point. It may be a little earlier, a few minutes later, since we started a little late this morning working on other issues. We'll take a break, members, a snack break here for everyone in about another 30 minutes. Okay. OSSO.
I may want to try to do it. If that's okay. If that's okay. Cool.
Members, we're not on a break. We're just waiting for the other witness to come in. Just want to let you know. But feel free to stand and stretch.
Thank you.
Mr. Bangert, come forward. I need to swear you in. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth. So help me God. Thank you.
Good afternoon.
Good afternoon.
State your name, please.
Ryan Lee Bangert.
All right. Mr. Bingert, I want, if you will, to keep in mind a couple of things. The way you're positioned is perfect for the microphone, I think, in every respect. You don't have to take your hands down. And if you think I am not very, if I've moved to go out inadvertently, I want you to call me on it and vice versa, okay?
That's fair.
How old a man are you?
I am 46 years old.
And you might want to be a little closer to the microphone, but see if you can, I think you can bend it towards your face. It might work out a little better. All right, thank you. Where do you live?
I live in Bee Cave, Texas.
So could you take us through and try about a minute and a half, sort of your own personal background, where you grew up, your parents, et cetera?
Certainly. I was born in a small farm town in Illinois called Quincy, Illinois, about an hour north of St. Louis on the Mississippi River.
What did your parents do?
My father's a salesman. He did not complete college. My mother is a school teacher.
And do you recall, what size town was this, by the way?
40,000, give or take.
And that's a little bit bigger than my 9,000 in North Carolina, so 40,000 we considered a big city. Let me ask you this. When you finished high school, where did you go to college?
Certainly. I moved to Fort Worth, Texas when I was in second grade.
Right.
And did grade school there, high school in Omaha, Nebraska, and then I went to Oral Roberts University for college, which is in Tulsa, Oklahoma.
And then what about law school?
I graduated ORU in 1999 and started law school at SMU in 2001, and in the intervening 2 years, I successfully pursued my wife, who agreed to marry me.
And where did you finish in your class?
At SMU?
Yes.
I was first in my class at the law school.
And where did you go from there?
From 2004 to 05, I clerked for Judge Patrick Higginbotham on the Fifth Circuit Court of Appeals.
And after that, in 2005, and let me stop you there. You would have been approximately what? What age by the time you finished clerking for the Fifth Circuit?
About 28, maybe 20. I was 28 years old.
Had you picked, by that time, had you also been involved in Republican politics or other outside activities?
I had been at Oral Roberts University. I had been the student body president, but I'd also been an officer in the college Republicans. I had interned for a Republican congressman on Capitol Hill named John Christensen from Omaha, Nebraska. I'd also served on his campaign. I'd been an intern for a group called the Christian Coalition. I'm not sure if they exist anymore, but I was an intern for them back in the late 90s. I also was a Blackstone Fellow in law school.
What is a Blackstone Fellow?
The Blackstone Fellowship is a summer fellowship program that is administered by Alliance Defending Freedom. And we collect what we would say are the best and the brightest conservative, faith-based law students in the country. And we train them for about 2.5 to 3 months in originalism, textualism, natural law. We give them excellent access to internships, and we also commission them as fellows.
Mr. Banger, tell me this. What role has your religion played in your life, both as a student and as an adult?
Very significant. It's
In what
the basis
way?
for everything that I do.
And has that always been true, or is that later in life?
It's always been true. And of course, as anyone would tell you who's been a believer most of their life, you have your ups and downs, but certainly it has been the guiding star in everything that I do.
You're aware, or you're not, of the allegations that have been made publicly, and indeed by Attorney General Paxton and others similarly involved from his point of view, defenders of his, that this is somehow, this impeachment process itself is somehow in the hands and caused by outside groups that do not share conservative values. You're aware of that?
I have heard about that, yes.
All right. would you please tell us and give me an idea of, for instance, your political philosophy, in the sense if we're on a scale of 1 to 10, and 1 is very, very, very far left, and 10 is very, very, very far right, where do you fit in?
Well, I don't think anyone would have ever accused me of being far left. In newspaper articles describing me leading up to this trial, I was described as working for an extreme conservative group. I believe I work for what I would call a Christian legal advocacy organization, but my politics are very much conservative. My party affiliation has been and always will be Republican, and I have long been associated with what I would call the conservative legal movement. That includes the Federalist Society, the Philadelphia Society, and of course the Blackstone Fellowship.
So if someone would refer to you as a rhino, what is your reaction?
That would be remarkable, and I can't imagine that having any basis in reality.
What are you presently doing? What is your present job?
I presently am the the senior vice president for strategic initiatives and advisor to the president for a group called Alliance Defending Freedom.
Called what?
Called Alliance Defending Freedom.
And the Alliance Defending Freedom is what?
We are a global legal advocacy organization. We specialize in defending religious freedom, freedom of speech, life. We also work very closely on campus with groups who are having their free speech stifled by universities. We also support parental rights. I think that it's fair to say that if you were to put us on a political spectrum, we would be conservative very much, although we are a nonpartisan organization.
At the time, the jury has just heard for several hours from Mr. Mateer. How long have you known him?
I've known Jeff for quite a while. I knew him back when he was at First Liberty Institute prior to joining the Attorney General's office. And I did several cases with First Liberty Institute as a volunteer attorney when I was practicing law at Baker Botts, which I don't think we've talked about, me joining Baker Botts. But when I was there, I was a volunteer attorney for First Liberty.
Yes, when you left law school at SMU, and then after you left clerking for Judge Higginbotham, what did you do?
In 2005, in the fall, I joined Baker Botts in Dallas, Texas. I was an associate there until 2013, I believe, when I made partner as a litigation partner. I was there as a partner until 2016. Right after the election of President Trump, I received requests that I consider joining in the government. At the time, we weren't in a position life stage-wise to go to Washington, D.C., and so I was asked by then Attorney General Josh Hawley to join his administration in Columbia, Missouri. And we had some back and forth, but he's a very persuasive guy.
So when you joined him, what position did you have with Josh Hawley?
I was the deputy for civil litigation, so I ran all the civil litigation in Missouri.
And what was his position?
Josh Hawley was the Attorney General for the state of Missouri.
And of course, since has gone on to other things.
He has. He ran for and won the U.S. Senate seat in Missouri over Claire McCaskill while I was there.
Can we safely concede that Senator Josh Hawley is a very conservative man?
He's a very principled, conservative man.
And how long did you work for him in the capacity as Chief of Staff?
I was 2 years, and I was the deputy for civil litigation.
I'm sorry. Did you obviously end up being offered another job before you left?
I was spoken to by the incoming Attorney General, Eric Schmidt, about potentially joining his administration. Incidentally, Mr. Schmidt is now the junior senator from the state of Missouri. But during that time period, immediately after the 2018 election, when Josh had won the Senate seat and General Paxton had won re-election, Jeff Mateer and I were texting back and forth, and Jeff said, "I think it's time for you to come home."
Did you do so?
I did. I know Brantley Starr, who was a friend of mine and at the time was the deputy first assistant in the office, had been nominated by President Trump to become a federal judge. And Jeff recruited me because we knew Brantley was going to be leaving.
Could you imagine how anybody could be legitimately contending you and Mr. Mateer and the team that was put together at the Attorney General? How could anyone reasonably, legitimately contend that you guys were some kind of ultra-liberal force that was designed to take over and thwart the true conservative mission?
Assumes facts, not in evidence and relevance, Your Honor.
I'm sorry. I'm simply
restate?
asking you about it. Can you imagine how anybody could take that position? I thought I was taking a shortcut to bringing in evidence on it. All right.
It would be fantasy, pure and simple.
All right. Now, let me ask you, when you left and came back, did you come to work then for the Attorney General's office?
I did. In January of 19, I joined the Attorney General's Office of Texas as the Deputy for Legal Counsel.
And what were your duties as the Deputy of Legal Counsel, and what month did you come back?
January of 2019.
All right. And what were your duties? What did you oversee starting in January of 19?
The Deputy for Legal Counsel oversees a number of different functions within the office. Open Records is one of them. The Opinion Committee is another. The Public Finance Division is another. The General Counsel Division is another. And I was also tasked with overseeing a group called Special Litigation. Special Litigation is a strategic litigation unit within the AG's office that both brings and defends strategic key litigation on behalf of the state.
Now, let me ask you, do you recall the first time you might have ever become aware of a Mr. Nate Paul?
I do.
When was that?
It was either at the end of December of 2019 or early in January of 2020.
Was he on your, the evidence is clear in here that on August the 14th of 19, he had a search warrant executed by a combined state and federal task force at his house and businesses. Did you happen to notice any publicity or anything about that in August of 19?
No.
All right. What was the occasion for you becoming aware of Mr. Nate Paul in either December or January of December 19th or January of 20?
The Attorney General spoke to me about an open records file that he wanted me to take a look into. I also contemporaneously received an email from Jeff Mateer to the same effect.
All right. And did you talk to Mr. Mateer about it, or did he just forward you the request?
He forwarded me the request. I cannot recall whether I spoke with him or not, but I certainly spoke with the Attorney General.
What was the nature of the request that he referred to you to consider?
The request was basically it was called a reconsideration, a recon, of a previously issued open records decision that had been issued by the Open Records Division.
Had you ever before been involved in Missouri or any other, working with an open records request?
My time in Missouri, I was primarily responsible for litigation, so my experience with open records requests in Missouri was relatively limited, but by the time that this came about, I'd been working with it for over a year here in Texas.
Would you briefly describe for the jury the open records process as it is handled by the Attorney General's office?
Certainly, and I'll do my best to summarize. The Attorney General's office is responsible for ruling on requests by agencies or state governmental bodies who have received open records requests from citizens and who wish to withhold information based on an open records exemption or an exception. And the Attorney General's office will evaluate those requests and then rule on them through a series of letter rulings. We receive thousands upon thousands of these requests every single year. It's all handled through the Open Records Division. They're handled by a team of attorneys who specialize in open records law. And they are, let's just say that it is a well-oiled machine.
And what are we talking about when we say the law enforcement exception?
Yes, there are a number of exceptions in the open records provisions in Texas law. The law enforcement exception is one of those. It's designed to protect law enforcement when an ongoing investigation is taking place against having the defendant or other interested parties procuring information from law enforcement that would disrupt the investigation or potentially compromise witnesses or compromise safety, quite frankly, of those involved.
Does it matter whether the law enforcement agency is a federal or state or local law enforcement agency?
The rules apply slightly differently. The rules are designed for state law enforcement agencies, but we do, as a matter of comity, when there's a FOIA exception for federal law enforcement agencies, honor those requests as well.
But it is essentially a state statute designed, is it not, to regulate or respond to requests that would invoke local or state law enforcement, correct?
Yes.
But if something is to affect, say, if FBI is one of the agencies in a particular event, is it designed to address that as well?
It does.
How does it do that?
We have a number of open records rulings that we've issued, and you'll have to forgive me if I forget the numbers of them. It's been a while. But we effectively agree to honor requests posed by FBI or other federal law enforcement agencies to withhold information, oftentimes information that has been provided to state partners in the conduct of joint law enforcement activities.
So if there was a joint law enforcement operation to involve like 4 different law enforcement agencies, could be FBI, could be DPS, could be local police departments, it could be some regulatory agencies that have law enforcement capability and involvement. If in any of all those situations, does the AG's office treat that as a law enforcement exception agency?
It's law enforcement exception specifically with respect to state law enforcement agencies, and we'll treat that as a matter of comity, a law enforcement exception for the federal agencies as well.
All right, let's take the incidents that you said you were not aware of at the time it occurred involving Mr. Nate Paul. And among the agencies that were involved there were people from the Securities Board, all right,
Correct.
State agency, from the DPS, state agency, and also the FBI. Would any of those agencies be treated differently?
Functionally, no. No, they would not.
And what does that mean functionally?
It means that the analysis in the open records rulings differed slightly with respect to the agencies, but the outcome was always the same. We would not force those agencies to disclose law enforcement materials that were subject to the exception in the Texas Code for Texas agencies or FOIA for federal agencies. We would allow them to withhold that information. And I also want to point out these requests that were going to the open records requests were being posed to Texas law enforcement agencies.
All right. So a private citizen wants to complain about some matter in a search warrant or whatever. What would they do, and how would the process prefer? So let's say a private citizen and his lawyer want to get behind a joint operation by law enforcement and file a Freedom of Information request. How would that proceed?
Same as every other request. The request would go to a Texas agency or a Texas law enforcement agency. They would then submit a request for a ruling to the Open Records Division. And when the law enforcement exception applied, which in these types of cases where there are joint law enforcement activities taking place and they're ongoing, we would almost always withhold the information.
So if, in the example I cited, Law Enforcement Capability Board, Securities Board had people present, DPS had people present, FBI had people present conducting it, how would you proceed with each of those agencies?
The agency making the request to withhold would brief the issue. Interested agencies would then receive an opportunity to submit their own briefs.
Let me start here. If the request went to the Securities Board, what would be the process then, if the first request went to the Securities Board?
The State Securities Board would, if they wish to withhold information under the state law enforcement exception, the Securities Board would submit a request for a ruling to the Attorney General's Office Open Record Division. That request would then be adjudicated by our attorneys. And sometimes there was additional briefing. If there's a party who was seeking the information who wanted to brief the issue, they would submit briefs and we would rule upon it.
All right. And then what would you do about if there were other agencies that had information in there? And obviously, if the request originally went to the Securities Board, would there be possibly information there from DPS and from the FBI? How do you handle that in letting them know whether they can weigh in?
They're notified of the pending request and given an opportunity to brief.
They would be notified as well?
Yes.
So would you notify then each law enforcement agency of the request, even if it just went to one of them?
Typically, yes.
Okay. Now, in this particular time in December, January December of 19, January of 20. Would you describe for the jury how you got involved and what you did and what the request was that you were asked to look at by Mr. Mateer?
Certainly. There had been a request made, I believe it was to the State Securities Board, for information relating to the law enforcement actions taken against Nate Paul, concerning Nate Paul. And there were a number of different pieces of information and documents that were requested. I did speak with the attorney for Nate Paul.
Do you recall who that was?
It was someone at the Meadows Collier firm in Dallas.
Something in the Chuck Meadows firm in Dallas?
Yes, Chuck
All right.
Meadows firm in Dallas.
Did you?
Had dealings with them before on other matters when I was at Baker Botts.
So you already knew the firm?
I did.
All right. So what did you do?
I spoke with them to understand the contours of their motion for reconsideration. Based on my review of the record and through conversations, it became apparent that the thing that was most concerning to the Meadow Collier's firm was getting access to a particular document known as a probable cause affidavit. This is the affidavit that would have supported the search warrant of Mr. Paul's home. There were multiple
And
warrants.
did you discover whether or not that affidavit was actually under a federal seal in San Antonio?
I did, and I learned that it was under federal seal, yes.
And I'm not sure, you mentioned it, that I'm not sure we were clear before this. The actual event that gets to you, was that the first time the AG's office had been involved in this request, or were you being asked to reconsider a previous decision?
It's the latter. We were being asked to reconsider a ruling we had already made, finding that the documents should not be disclosed, and that includes the probable cause affidavit, should not be disclosed.
And do you recall whether the previous one had whether the FBI had weighed in on it as well, or was it declined initially without even hearing from the FBI?
I do not recall because I wasn't involved specifically. That would have been a routine matter, and the denial of the granting of those exceptions and the refusal to force disclosure would have been routine. It was unexceptional.
Was there anything unusual about the decision you were reviewing in terms of its actual decision itself, namely that the law enforcement exception dictated that the information would not be revealed?
No,
Was there anything?
When I reviewed the decision, it was unremarkable to me. It appeared to me to be a straight application of our existing precedent.
And what did you do when you looked at it? What's the first thing you did?
Well, I reviewed it. I understood that there was a motion for reconsideration pending, so I also took that issue to Justin Gordon. Justin was at the time the head of the Open Records Division and was one of my direct reports. I asked him to pull the file, to look at it, to evaluate the decision, and make sure that we had covered all our bases, because a motion for reconsideration, we did get those from time to time. They were almost in all cases denied out of hand.
Yeah, I was going to ask you that next. And in all the cases you touched or watched while you were there, how would you rank the number of occasions in which the law enforcement exception was not adhered to?
Difficult to quantify, but it was been a very unusual thing for a straight application of that exception not to be granted. In fact, I don't know if we ever did it.
So it would be accurate to say that you don't know of one that you had encountered?
I'm not personally aware of a situation where that exception applied where we would not have granted it.
Did you look into Mr. Paul at all yourself?
Say again?
Did you do any research on Mr. Paul?
I did.
What'd you do?
I Googled him.
The ultimate research tool.
Right.
And how did that impact your view?
It made me very concerned that I had been asked to, well, let me back up. I learned through my Google research that Mr. Paul had indeed been, his home and several properties been searched by the FBI, that he was under active investigation by federal law enforcement. And as someone who is a senior staff member, that immediately sends up red flags when you're being asked to review a file for reconsideration to disclose law enforcement materials to someone who is under an active and very far-reaching investigation.
Tell me what the danger is, or what the policy position was in your agency in terms of why would you want to adhere to this sort of rigid rule that if it involves ongoing criminal investigations, you would cite the law enforcement exception? What's the reason for that?
The policy reasons, there are a number of policy reasons for that.
Don't get too far away from the microphone.
Oh, my apologies.
It's okay.
Certainly, there are a number of policy reasons for that. One of which is you would not want to compromise in any way an ongoing criminal investigation, particularly by state agencies, by releasing information that could cause that investigation to be not able to go forward. More importantly, you also don't want to compromise the safety or the identity of potential witnesses or the safety and identity of those who might be conducting the investigation. So there's both a public policy interest in ensuring the integrity of our law enforcement activities here in the state. There's also a public policy interest in ensuring the safety of those who are undertaking those activities or serving as witnesses.
I was about to ask you, those files, how would you rank whether or not, how often they have actual personal data with people who have cooperated with law enforcement or citizens who have given information but want to remain anonymous as much as they can, the names of people that are involved? How would you describe the potential risks of them if this information started being revealed to whomever was curious, whether it was media or the offender themselves?
Objection to relevance, Your Honor. I mean, it's not with regard to a specific document here.
I'm
It's an
sorry,
overly
repeat
broad
your
question.
objection. I couldn't hear you clearly.
It's an overly broad question, Your Honor. It doesn't specify what specific document that the witness is going to be referring to.
My question is, I'm asking him what the danger and the policies of these things, which goes directly to why they were going to be concerned about releasing this information to Mr. Paul.
Well, I think Mr. Bangert's already answered that question, Judge.
I'm sorry.
I would say that Mr. Bangert's already answered that question.
Overruled.
Thank you.
Could you state the question one more time, Mr. Hardin?
Yes. My question is, I'm asking, what is the danger and the policy of these things, which goes directly to why they were going to be concerned about releasing this information to Mr. Paul?
Again, safety concerns are paramount. You never want to compromise the identity or the safety of witnesses. And certainly, when I was reviewing files, and I only reviewed files that had what you might call hair on them, or files, in this instance, that didn't have hair on it, but at the request of the Attorney General. There were files where witness identity, sex crime victims in particular, might be revealed. Those were always very concerning. We want to make sure those were properly dealt with.
Yeah. Mr. Bangert, do your decisions when you were making these open records requests, if you're not careful about how you do it, are you ever concerned about your setting a precedent that would even be worse than the individual case you're looking at?
Precedent is very important to the Open Records Division. We want to be rigorous in ensuring consistency to the utmost. We want to ensure that as we apply the law, it is applied evenly and consistently for all Texans.
Well, then, if in fact you released the information that Mr. Paul and his attorneys were seeking, that would have given you, what kind of information would that have given them, the person under investigation?
I was very deeply concerned, in particular, about what it would have done to our precedent to overrule the law enforcement exception applied in this case being the reconsideration motion I was asked to review by the Attorney General, because there was a probable cause affidavit in play. Not only that, a probable cause affidavit subject to a federal seal that was part of an active, ongoing, multi-agency investigation. That would have been, in my view, a very poor precedent for us to set and would have disrupted law enforcement activities in the state of Texas.
Did it include what we commonly call offense reports, in which identifying data of the officers and the witnesses were included?
I'm not familiar with that term, but certainly...
Forget the officer. Let me give you, excuse me for interrupting. Let me see if I can give you another term. Would it have included memos about what happened and by whom and who did what, so that personal identifying data would be in there about law enforcement and anybody else, witnesses?
Certainly, law enforcement exception covers documents that contain personally identifying information for law enforcement and witnesses.
And would that file, that would also include the names and addresses potentially of victims
Objection
or
to improper
witnesses?
foundation, Your Honor. This witness hasn't. He hadn't laid the foundation to establish he has knowledge of the file.
I'm simply asking him what all is there that they're trying to protect.
Overruled.
Thank you.
There's a whole panoply of information that could be included within documents covered by the law enforcement exception.
So when this was over, well, let me ask you this. During your deliberations about this matter in January of 2020, did you have any contact with the Attorney General about it?
I did.
And what was the nature of that? When, where,
Certainly.
how, what?
Initially, the Attorney General asked me to review the motion for reconsideration. Unusual in the sense that he typically did not involve himself in open records requests, but he is the Attorney General, and I certainly wanted to honor and fulfill that request, so I reviewed it carefully, and I very quickly reached the conclusion that the decision was correct, and I advised him of such.
Let me go back for a moment. When you were hired, did you ultimately, though I believe you said that you were recruited by Mr. Mateer, but did you have contact with the Attorney General and meet with him before you were hired?
I had, not before I was hired, but I had contact with the Attorney General going all the way back to 2014 when I was a partner at Baker Botts. I contributed to his campaign. I supported him during his primary campaign. I believe it was against Mr. Branch. I believe I was the only partner at Baker Botts who did so, so I was told. But I believed in what he was doing. I believed his policies were the best for Texas. That's why I joined his office in 2019. I believed in what he was doing, and I also believed Texas was leading the way in representing the interests of the conservative legal movement here in the U.S.
So would you characterize yourself as a strong supporter?
At that time, yes, I was. That's why I joined the office over other opportunities that came my way.
So in addition to this reconsideration request on the Paul case coming from the lawyers for Mr. Paul, where in that scheme of things did the Attorney General reach out to you as well and ask you to look at it?
Again, it would have been toward the end of December or beginning of January, either 19 or 20. He asked me to take a look at it. I did. I reviewed it, came to the conclusion that it was correct. Typically, in instances like that, the Attorney General would say, "Thank you for that review," and we would move on. This was different, and it struck me.
How was it different?
He pushed back, and he pushed back not necessarily by contesting my application of law, but by saying it doesn't seem fair to me that a defendant should not have access to something like a probable cause affidavit, something that's being used to investigate him.
Was there any conversation? Well, that would be a consideration for the judge and courts that were involved that he should go to, or tell me about any conversation or response you had.
There was federal case law on that point, and I shared that with the Meadows Collier firm, pointed out to them that all they needed to do was go to the federal courts and file motions with the federal judge, and if they were denied, they could go to the Fifth Circuit, and there was good case law there too, and I shared those facts with the Attorney General as well. There was a federal option. What
was Attorney General Paxton's response?
The Attorney General shared with me his view that he had been wronged by law enforcement and was uninterested in having other Texas citizens wronged by law enforcement as well.
Did he express to you any further, as far back as January of 20, his views of law enforcement?
He was clearly very skeptical of law enforcement when we were having those conversations. I was surprised by the level of pushback I got to what I viewed as a routine application of the law, but we continued to have those conversations with him all the same.
Well, once you made your view known, and once he pushed back, did you have any further conversations with him?
We had a series of conversations.
About this subject?
About this subject in January.
Excuse me, about this case as well?
We had a series of conversations about this specific open records request, the one for reconsideration of the SSB request, yes.
The one on behalf of Mr. Paul?
Yes.
How many times would you estimate that you had conversations with the Attorney General in which he was urging you, or was he, in these conversations, was he urging you to take a particular position?
He was certainly applying pressure to look for any way possible to disclose the probable cause affidavit. He did not instruct me to override or overrule our existing precedent at that time, but he was very interested in finding any way he could to have that probable cause affidavit released.
And what was your reaction?
I told him that that would not be a good idea.
So ultimately, was it disclosed at that time?
It was not disclosed at that time, to my knowledge, no.
How did the issue end? I mean, how did you move away from it?
I think we may have just worn each other out on that, but he
what?
did.
I'm
We
sorry.
may have just worn each other out on that, but he did eventually. And of course, remember, we're now ramping up into COVID in 2020. February and March was the beginning and the explosion of COVID. So other events began to overtake the office very quickly.
And actually, in February, as early as February of the COVID year, 2020, before everything really breaks out the middle of March, did you yourself give talks and research and conclude it was going to be a huge issue, particularly as it affected the legal things that the AG's office was going to have to get involved in?
Yes, we, even before March, when COVID became a reality for most Americans, we were wargaming, planning, having internal meetings about what the potential legal effect would be if a pandemic were declared and COVID hit our state.
Did the Attorney General's office have a position from the very beginning, initiated and urged by the Attorney General, as to what y'all's legal position was going to be in dealing with the COVID plague, in the issues of whether it's masks or whether it's meetings, whether it's gatherings, whether it's activities? What was his position that each of you were challenged to carry out?
Yes. The situation was very fluid in March. I would say we didn't have a position per se, but very quickly over time, as states began shutting down, canceling school, mask mandates were imposed, stay-at-home orders were imposed. Very quickly, it became the policy of our office, and I would argue the policy of the state of Texas, to do everything we could to keep things open as much as humanly possible, consistent with public safety.
Counselor, I went a little past our break, I promised, for everyone involved. Is this fine?
This is fine. This is perfect.
We'll break till 20 after, take a little bit, it's a 20-minute break, 10 after, 20-minute break, 10 minutes after, 20-minute break, get a snack, and then we'll go to about 6:30. We'll go another hour when we come back.
Thank you, Your Honor.